forward to a hearing on the prelim in this case, and the request for jurisdiction over the children. May I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, legal guardian ad litem for the minor children.
Good afternoon, Your Honor. Clay Tipton, department.
And I'll try with the department.
Michael McFarland representing mother. Please introduce yourself.
Robin Hardy.
Did the court hear that?
I did not.
Robin Hardy.
All right, would you spell that for us, please?
R-O-B-Y-N.
Henry Dumont for father, Tyler Long.
I'm Tyler Long.
L-O-N-G?
Yes.
Got it. Okay, thank you. All right. I know we were on record one other time and we made the decision to adjourn this to allow the attorneys to talk with their clients. Have you had a chance to do that, Mr. McFarland?
I did, Your Honor. If the court finds there's sufficient today to proceed, we are requesting bench trial.
Okay, that's good.
But we are prepared for today.
Very good. Have you had a chance to talk with your client, Ms. Dumont?
Yes, Your Honor, and we would be requesting the same thing.
All right, 2 bench trials requests. Good. Well, I can set about scheduling that, and in the meantime, let's go over some of the preliminaries for our prelim hearing. Deputy Ames, would you swear in Mr. Tyler Long and Ms. Robin Hardy, please?
You can remain seated, but please raise your right hands. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Can you say that out loud, please?
Yes.
Thank you. Thank you.
Okay, thank you. So I just have some questions for both of you, many of which you may have already had the answer in the process of looking through the petition, but I'm going to go over that with you one more time. Do each of you have a copy of the physical petition? Ms. Hardy, do you have a copy? It's
What we went over now.
Yes.
okay. Mr. Long, do you have a copy?
Yes.
Very good. All right. Are there any other cases? It looks like there's a DC case for the older child. Are there any other cases that you're aware of, like a guardianship, child support case, or anything else that could concern either of your children? Ms. Hardy?
Not that I know of. I don't even know what that first thing is.
Okay, well then that probably doesn't apply. Mr. Long, any other cases that you're aware of?
No. Your Honor, I will say one thing that we did not see that it was said it was attached with the petition is the safety plan.
All
But
right.
not in my petition. I didn't see that in my client side.
Which allegation?
I will go back and read that.
Okay. All right, I'll let you look at that then as I go through these things. So both of you have the right to an attorney for purposes of this and all proceedings. If you want to retain your own attorney, that's fine. That person would have to contact the attorney that's been assigned to you to get the information they need moving forward. But Mr. McFarland and Ms. Dumont will be here to assist you until and unless that decision is made. You have the right to ask for placement of your children, and at this time, it does not look like the department is asking for the children to be removed from your care. We're just asking the court take jurisdiction and direct to avoid some of the things that they are noticing that they think are risks in the household. You have the right to have the petition read to you on the record, including all of its subparagraphs, which looks like it's a total of 4 pages. Mr. McFarland, have you talked with your client about that?
Yes, I have read that word by word. She does have some learning difficulties, so I went in more simple terms also with her. And in answer to your earlier question, it was number 8, which references C attached. Number 8 is the safety plan.
Thank you. Do you know if your client would like me to read the allegations or if she would like to waive that?
No, we would waive that, but we just haven't seen, I've not reviewed with her the safety plan.
Thank you. Duly noted. I'll let the workers worry about that and maybe we can remedy that by email.
Yes.
Thank you. Okay, Ms. Dumont, have you talked with your client about his right to have the petition read and would he like to exercise it or waive it?
Your Honor, we would waive that. We have went over the petition together.
Thank you. Very good. All right. Do either of you have any Native American heritage or have any reason to believe that anyone in your family could qualify for that or that your children may be eligible for membership in any Native American tribe or band? Ms. Hardy.
A little.
I've discussed that with my client in the presence of her father, and he believes there is Native American heritage on his side of the family.
All right. It does look like there is a BIA request that's already been sent out on that point. Do you Have you asked your client if she's provided all possible information about that already?
Yes, I'm not sure if anybody has spoken to her family, her father, or anybody else on that side. But I think she knows she's disclosed.
Okay. All right, just put a pin in that and we'll follow up with you in a minute on that. All right, how about your client, Ms. Dumont? Have you talked to them about that?
Yes, Your Honor, he indicated his mother, right, might have a little bit, but he doesn't believe it's enough to warrant an investigation.
Would you be interested in supplying that information just in case?
Yes, Your Honor. Your Honor, he doesn't know what tribe or how much it would be,
Okay,
so.
thank you for asking. All right. Each of you have the right to trial by judge or by jury, wherein the court would have to determine whether or not there's probable cause to move forward on the petition. And obviously, your attorneys have talked with you about that. You would wish to request a bench trial, which is great. I'll schedule that. You would also have the opportunity to admit or deny the allegations and make a statement of explanation. Do you have an official position on that, Mr. McFarland?
Yes, Your Honor, if I stated on the record, if it does proceed to trial, we wish to have a bench trial.
Thank you. Same question, Ms. Dumont.
Yes, Your Honor, we would agree we would want a bench trial.
Guess my only concern would be, we want to hear back from any possible tribes or Department of Indian Affairs prior to proceeding.
Well, we'll hear an update on that very soon, I'm sure. I do have documentation that was supplied with the petition, and I'm hoping you all do as well, that request to the BIA went out on 9/16/2024. So we're looking for an update on that. Looks like legal parentage has been established for your client, Ms. Dumont, by way of an affidavit of parentage for both children. Any reason we would need to be concerned about those determinations?
No, Your Honor.
All right. All right, so for purposes of today, we're just looking to determine whether or not there's probable cause that one or more of the allegations of petition are true and fall within the statute for purposes of moving forward on the petition itself. Rules of evidence do not apply, and that's pursuant to MCR 3.965 subsection 12. At this time, Mr. Tipton, how would you like to proceed?
Okay, Your Honor, I guess I maybe have been confused. Are you asking Ms. Dumont's client if he's the father of all the children?
I only have 2 children named in the petition, and I have 2 AOPs.
My client indicates that she does not believe he is the biological father of one of the children. I can have her placed on the record. There's another possible father out there. I just found that.
Well, we do have an affidavit of parentage for both children, so
Okay,
he has been determined to be the legal father. I'm not really, I wouldn't be obligated to move, or the department would be able to move if I ordered them on a DNA testing, but is that something?
well, I guess, Your Honor, let me talk to my client. I mean, if there's something she discovered after the fact, I don't want her to commit fraud in filing a document like that, but if we possibly have another father out there that has legal rights, well, I can just confer with her. I just discovered this. If I can take her up in the hall just a moment.
Well, any such person would have to file an action to set aside that parentage under the Revocation of Paternity Act.
Well, I know this court has also done that. Testimony determines that there was some type of fraud or concealment, intentional or accidental on that matter. So I've not explored that, but I've just been told that there may be another potential father out there.
What is the name of this person?
Yeah.
And is
He
it for
doesn't
the older
want-
child
Judge,
or
court
the
just
younger
needs to know his
child?
name.
He doesn't want to be known as
Judge is
the
asking,
father.
judge is asking.
He doesn't want to be known as the father.
Is this for the older child or the younger
Yeah, the
child?
older child.
Okay. So are you asking us to investigate that or not?
No, he's the dad,
Who's he?
Tyler. I have legally and everything since birth.
Yes, I'm aware of that. I have legal documentation to that effect. Is there a reason to believe that we should investigate that any further?
No,
Okay,
I would like to confer with Ms. Dumont for just a moment, Your Honor.
Sorry.
Well, why don't we leave that, we have a legal father, why don't we leave that until the end of today's proceedings? And then you can let me know how you want to move on that at the next pretrial. My intention is to schedule a pretrial and a trial.
Fair enough.
Thank you. All right, so for purposes of today, Mr. McFarland, let's stay with you. Your client does certainly have the option to waive the probable cause finding and to allow the petition to move forward. Or we can ask Mr. Tipton to present any evidence that he may want to in order to allow this to move forward. What
We
would
wish
you
to have a
preference?
presentation of evidence.
I'm sorry?
We wish to have a presentation of evidence.
All right, Ms. Dumont, does your client wish to waive the probable cause finding, or would he too like to hear what the department has to say?
We would like to hear what the department has to say, please.
Okay, Mr. Tipton, back to you.
Just had a trial to the stand, and also the supervisor of the department as well was booted out of Zoom as a consequence of.
Oh, yes, I do see her in the waiting room, so she's back in. All right, come on up to our witness stand, Ms. Hannah Trout.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right, proceed it well.
Are you the Family Services Investigator for the Department of Health and Human Services?
I am.
You're also the petitioner in this matter,
I am.
and you're the petitioner regarding the children AL and RL.
I am.
And how old is AL?
I'm sorry, I don't know off the top of my head.
5 years old, is that?
Yes, that sounds right.
Okay. And RL is an infant?
Yes, he's only a couple months old.
Okay, and how did you become involved with this case?
We received allegations when the infant was first born that his meconium was positive for THC.
Okay, and at the time, was there a safety plan developed?
Yes, there was.
What was that safety plan?
There was a marijuana safety plan developed in regards to not using in the presence of the children, not using when you're alone with the children, that there would be a sober caretaker in the home, having the substances locked up, and then not driving if you're going to use.
Your Honor, I'm objecting, and the reason is, as I stated, we don't have a copy of that safety plan that was attached. I thought we could be provided with that.
Well, is there an evidentiary aspect to your objection? She's just testifying to what her recollection is of that safety plan. You're welcome to cross-examine and to continue making that request in the future, but if there's something more specific that I could look at under the rules of evidence, I'd be happy to look at.
Well, it's hard for me to cross-examine him. I don't have the document that was supposed to be supplied in the petition itself.
Yes, Mr. McFarland, is there a specific objection under the court rules you'd like me to entertain?
No, not, well, not at this point, Your Honor. I will withdraw that. I'll come to that.
Very good. I remain at your disposal should you decide otherwise, and I think there was, do you want to speak to that quickly?
It was supposed to be attached with the petition. I apologize that that did not get circulated. I did make sure that our attorney, I emailed it to him just now when you guys were talking, so he should be distributing that probably shortly after the hearing.
Does that help, Mr. McFarland?
Yes, Your Honor.
All right, sorry, you may continue.
No problem, and I appreciate my client falling on the sword, but it may have been my error in not attaching it to the petition, so we'll get it to counsel immediately.
Thank you.
And did you have an opportunity to speak with the mother of the children?
I did.
And who was that?
Robin.
And who was the father of the children?
Tyler.
Okay, he's the legal father of both children.
Yes, yes.
Okay, and did you have an opportunity to speak with her about why she was testing positive for marijuana?
I did.
And what was her response?
She claimed because of medically, she was in a car accident and has a lot of pain from that. So she uses marijuana to cope with the pain.
And was there a conversation of how, whether or not she was nursing the youngest child?
Yes.
RL?
Yes, she said that she is breastfeeding.
And Robin agreed to take any drug screens at the time during your investigation.
She did.
That investigation occurred, was it in August of this year?
It was August to September.
Okay. And what were the results of the drug screen?
So there was multiple drug screens. We conducted two. The first one, she tested positive for her Suboxone, which she does have a prescription for, and THC. The second drug screen, she tested positive for THC and alcohol.
Was that within that time frame of August of this year and September?
Yes, both of those were.
Could you repeat that? Sorry.
What was that?
Could you repeat that last statement? She tested positive for what?
Her first drug screen or her second one you need?
Both.
Okay, her first one, she tested positive for her Suboxone and THC. The second one was alcohol and THC.
And this was recently?
Yes.
Was that the only time you had contact with?
I did request to do a third drug screen with her, which she did not wish to complete. She said that she would go to Lenawee Development Corp the next day, which she did not do.
And was there any other time that you became involved with this case or had contact with Robin?
I don't know the exact number of times. I showed up a few times for unannounced visits and attempted phone calls with her. I can't say the exact number of time that I had contact with her.
Okay. And had Robin taken RL to his well baby visits?
Sporadically, there was multiple canceled appointments or no-showed appointments. He did go to a couple of them that were rescheduled, but they've been very sporadic since he was born.
Was there any important point in time that you as an investigator became involved or became concerned about one or more of the child well visits?
Yes, I called to follow up on one of his well child visits, and I was made aware that she showed up to the appointment appearing under the influence of substances. They said her words were very slurred. She was slow to respond. They could not say the exact substance, but they believed it was alcohol. She said that her mother drove her to that said appointment, but the hospital did not see the mother. Robin claimed that her mom was waiting in the car.
Okay, and as part of your duties as a protective services investigator, did you try to contact Robin?
I did. That is when I went out to the home a few hours later, and that is when I asked her to drug screen the second time. And that's the one where she showed up positive for alcohol.
Did she make any statements to you regarding that positive drug screen?
Once I received the results back, she claims that she did not drink any alcohol. She and Tyler believed it was something that she ate that would have showed up positive for alcohol. But they both told me that neither of them cook with any alcohol or anything along those lines.
And after that positive drug screen for alcohol, have you made any attempts to try to contact Robin again?
Yes, me and the ongoing worker has tried to make multiple attempts with very few that were successful.
Were there any family team meetings requested?
I
or
did.
conducted?
I did attempt to schedule a couple family team meetings. I ended up having to show unannounced and complete one. I showed up unannounced to the home, but Tyler was not home, so I went out later that afternoon when I knew he would be home, and we completed kind of an impromptu family team meeting, which is when we were discussing the alcohol results where they were denying everything.
Was there a safety plan requested by you or anyone in your?
We reiterated the same marijuana safety plan that was previously agreed upon. When I discussed doing an alcohol safety plan, they did not wish to complete one because they were denying any alcohol use.
Now, the Lenawee Development Corporation, what is that exactly?
They are a service that we use here in Lenawee County for drug screens, which I believe at the end of the month, we're not allowed to use them anymore. But they used to do drug screens for us.
And after, were either of the parents cooperative with you regarding communication or?
Very minimally. We've been able to make contact very few times. That the ongoing worker has been touching base with the family since I filed the petition. So I don't know the exact amount of contact that she has had with them.
And who's the ongoing worker?
Megan McVeigh.
And during your investigation, you had opportunity to speak with Tyler?
Yes, I did.
Okay. Was he cooperative with the safety plan or communication with you at all?
I was not able to make any phone communication with him. I called and texted him on multiple occasions, which I did not receive a response. He says he works a lot, which is why I never got a response. He assumed that Robin was handling everything. I was able to make face-to-face contact with him a couple times, where they would not, that is when we tried to do the alcohol safety plan, and neither of them would do that. And then I completed the marijuana safety plan with just Robin because I had no concerns of him using marijuana.
Did he make any statements to you regarding Robin using marijuana and nursing?
He was aware that she was using marijuana. He did not know the frequency. He just says he knew that she was using.
And did he know that Robin was nursing?
He did.
Okay. Does either of the parents have any CPS history?
Yes, they do. Not a whole lot. There was an investigation when the oldest child was born, and I believe one more after that, but I don't remember the exact details. I do know there was one substantiated case.
And does either of the parents have any criminal history?
I believe Tyler does, but I don't remember the exact. I believe he reported that he was on probation before and did have to drug screen for probation.
And what are you requesting regarding this petition?
At this time, we were just requesting for in-home jurisdiction and cooperation from the parents to participate in services.
Thank you. I have nothing further on it.
Very good. It looks in the petition, there's 3 CPS cases filed against Robin Hardy. 2019, 2020, and 2021. Do you know which, if any of these, were substantiated cases?
I believe I should have it marked in there. There should have been a category 3,
Okay.
which would have been substantiated.
One says opened, closed, and the other says nothing.
So
There's
okay, so then they were both substantiated. The open closed one would have been substantiated, and then no, we would not have had a ongoing worker with them. The just plain category 3 would have had an ongoing worker check in on them and refer services.
Thank you for that clarification. Mr. McFarland, cross-examination?
Yes, are you sure my client didn't advise you that she was attempting to breastfeed the child?
I do not remember her saying attempting. I know that she said that she was going to breastfeed. The word attempting, I don't recall.
So going to breastfeed means that's a future that she wasn't currently breastfeeding, but she intended to down the road. Am I hearing you correctly?
When there are infants and mothers report that they are going to breastfeed, they're breastfeeding. There was no formula in the home or anything, so I was assuming.
Go ahead.
I under assumptions that she was currently breastfeeding.
But she told you she was going to. Did I hear you correct?
I don't remember the exact wording that she said.
What do your notes reflect, please?
I don't have my notes on me. I have the written petition, but I don't have my notes.
So you tested the infant to make sure that the infant wasn't having marijuana in its system and was at risk, correct?
The infant tested positive, his meconium tested positive for THC.
That was a newborn, correct?
Correct.
That was not the infant.
We don't continue to test infants.
So you didn't have any concern that the infant was ingesting marijuana through mother's milk?
We can't test them, so
You can ask, right?
I don't believe so, unless hospitals do that. But that is not something that we can do. And we can't do like a saliva screen or anything on an infant.
Do you happen to know what's the concern with what level of marijuana in a child's system poses a risk of harm to the child that mom is using? Do you know?
I don't, I'm not a medical professional, so I don't know those answers or levels.
So really, you don't have any evidence that the child had marijuana in his system. Is that correct?
Correct.
Thank you. You have no evidence that the child had any alcohol in its system either from mother's breast milk, correct?
Correct. Again, we can't screen infants, so I would have no way of getting evidence for that.
Who have you asked that you can't screen an infant for either?
Per DHS policy, we cannot screen anyone under the age of 18, which includes infants.
Even with consent of a parent?
Correct.
You have to know that site so we can look it up?
You probably could just look up Michigan CPS policy. I don't have a number or anything else.
That's what I was asking. Do you happen to know?
I have a link on my computer of all of our policy. If you would like I could try to find the exact.
That's fine. I'm just asking if you know.
Okay.
What was mom's exact blood alcohol content when you said that she tested positive for alcohol?
Forensic fluids cannot give us an exact number.
That's all I need to know. Thank you. You then went to mom's place, if I understand, residence, and asked her to screen for alcohol prior to her screening, right?
Correct.
Did you smell alcohol? I don't see in your report or in your petition that you smelled alcohol in her breath. That's not in the petition, correct?
Correct.
I don't see in your report that she had eyes that were watered over. I don't see that in your petition, correct?
There were concerns of her demeanor.
That's not what I asked. I'm asking in your petition. I don't see any language where you observed her to be under the influence, correct?
I believe I did put my observations in my petition.
Yeah.
It's at my desk, though. I don't have the.
Well, if we could provide that to you, and could you tell us what number you're alleging that your direct observations?
That's what I'm saying. I don't have it. I can't tell you a number. I would have to flip through it and find what number it was.
It's number 13.
Okay.
Sorry.
How far away were you from her when she was talking?
Maybe about 3 to 5 feet.
Don't you think that you'd be able to smell alcohol if you thought her conditions were from alcohol?
Jackson, you call it speculation.
Well, let me rephrase that. I'll withdraw that. You've had some training as far as people consuming alcohol, I would presume, is in your job, right?
Yes.
One of those would be the presence of an alcohol odor, right?
Correct.
What did mom tell you as to why she was why she had maybe slurred speech or couldn't keep her eyes open? Well, let me ask you, didn't she tell you that she was deprived of sleep is why?
Yes, she said she was tired.
Mom, when you did get the test results back from some unknown quantity of alcohol, did you tell mom that she had the right to have that sample tested at her own expense? Did you tell her that?
So we sent out the samples, so I can't retrieve the sample back. But I told her that she could go to Lenawee Development Corp and do her own drug screen at her own expense.
How many days after she gave the test, submitted to the test, did you get the results back? About 5 days?
I believe it was about 5 to 7 days. It can take about a week or so to get the results back due to the quantity of the screens we sent out.
You know, if the samples still exist?
I don't.
No further questions.
Did you have some questions, Ms. Underwood?
Oh, I do have one, if you don't mind, Your Honor.
Go ahead.
Didn't my client tell you, as far as the sores with blood dripping down her face, that she was recovering from poison ivy? Do you recall that?
She did not tell me that.
Fair enough.
Okay, questions, Ms. Underwood?
Yes. Good afternoon, Ms. Trout. Can you hear me okay?
Yes, I can.
Okay. As far as the blood alcohol screenings that are done by forensic fluids, isn't it true that it'll only show a positive test for alcohol if the person tests above the legal limit?
That is true.
Okay. So a person's BAC.
I object in that she's not an employee there. I guess, how did she have that knowledge, Your Honor? So it'd be,
Can I speak on that?
Well,
It's in the
technically,
petition.
It's in the petition, 15. The information came from forensic fluids, is that right?
Correct, I called them.
I just wanted that testimony, Your Honor. Thank you.
Your next question.
Mr. McFarland asked if you had any evidence to support that the child tested positive for marijuana, and you indicated no. However, in your petition, it indicates that the child did test positive when he was born. Is that correct?
Yes, his meconium was positive for THC.
Okay. So that is evidence supporting that the child has tested positive. Is that fair to say?
Yes, that's correct.
Okay. Since the petition's been filed, and this hearing has been adjourned, is it you that has continued to make attempts to be in contact with Robin and Tyler?
No, that would be the ongoing worker.
Okay. Do you remember how many approximately well visits the youngest child missed?
I believe it would be between 3 to 4 well visits that were canceled or no-showed.
Before the case was transferred to ongoing, was there any additional attempts to drug screen either party?
So outside of the 2 where I received results, there was one other attempt after that, where she denied a drug screen.
Okay. If the court were to authorize this petition, what type of services would the department be offering this family?
So we have a couple services. We have safe care, excuse me, that this family was actually chosen for. They can't be referred, they have to be chosen. They were chosen for safe care. We also have a new program called My Family Together that could possibly be referred. There's also substance abuse counseling or general counseling if needed. But that would be something that Megan would work on referring for services.
Okay. Are you aware that there is also a pending retail fraud case against Robin at this time?
If I recall, I remember seeing it on her criminal record, but I did not recall exact details about it.
I have no further questions. Thank you.
Have you received anything back from your Bureau of Indian Affairs inquiry?
We have not, and I actually had someone check just a couple minutes ago and there's no updates for it.
All right, would you be able to supply a copy of what was sent to the BIA?
Yes, I can.
Thank you. Redirect,
No redirect, Jack. Thank you.
recross?
There's 2 questions.
Oh, you know what? I forgot Ms. Dumont because I can't see her behind.
Oh, I'm sorry, Your Honor. You're right, you're right.
I'm sorry.
Ask about that.
I'm really sorry.
Oh, you're fine.
Do you have any questions?
Just a few. Ms. Trout, you testified there is no indication that Mr. Long is using any marijuana, alcohol, anything like that.
Correct,
And so that's why you don't drug screen him.
correct.
Okay. And he advised you he has a pretty heavy workload and that's why he's not always available to be spoken with.
Yes,
Okay. Okay, and you placed in your petition that he has no CPS history.
yes, correct. None on him directly.
Okay. Okay. And I mean, with regards to the petition, there wasn't really anything and specifically involving any concerns with him and the children, correct?
There was just more concerns of him minimizing the concerns with Robin, the concerns of her usage and him knowing and not properly safety planning around, and then the concerns of the alcohol and him denying everything.
So he believes, and he had told you that she isn't consuming alcohol.
Correct.
And that possibly could be true depending on, the information that he has.
Yes.
Okay, Mr. McFarland.
Now that you've heard father may have Native American heritage, presuming you're going to now do an inquiry as far as ICWA for him?
I can send an additional one, but the original, we do include both parents no matter what. If he has additional family names and stuff, I can send out another one. Originally, it was just his name. I didn't have any family members. But his name is put on the original inquiry no matter what.
What's your concern for the child, that meconium was in the child? That in the meconium there was tested positive for THC. What's your concern with that?
So I'm no medical professional, so I cannot speak exactly of the concerns, but I do know when I spoke to the pediatrician, testing positive for THC and continued exposure can cause issues with the child developing and everything. But again, I'm no medical professional, so I don't want to speak directly on what the concerns could be.
There were no medical records from the birth of the child indicating any harm from my client if she did consume THC. You'll agree with that, correct?
Correct.
So even if there was THC, the child was not in any way affected by that based upon the medical records, correct?
I didn't receive everything from the medical records, so I don't know, maybe they did note something, but that would be a question better suited for maybe a lactation specialist that she has talked to, or the doctor themselves, of their concerns and how it could affect the child.
She's told you her lactation specialist says there's no studies indicating pro or con on that, correct?
She has told me that, but I
Thank
spoke
you.
to the lactation specialist and they told me otherwise.
Well, I don't see that in your petition, correct?
That was after the fact.
I have nothing further.
All right, now last chance for any redirect.
What did the lactation specialist tell you about?
She told me that she did express the concerns to Robin of marijuana usage while continuing to breastfeed. There are signs posted all over the office expressing concerns and the risks associated with it.
But she did express that to Robin. That's your testimony.
Yes, she did.
Thank you.
Do you have any other questions, Ms. Underwood?
No, Your Honor, thank you.
Ms. Dumont?
No, Your Honor, thank you.
Okay, Mr. McFarland, you've already had 2 shots, but any more?
Nope, I'm satisfied.
All right, thank you for your testimony. We return to your seat. Anyone else you'd like us to hear from, Mr. Tipton?
Yes, is Ms. McVeigh still with us?
Ms. Megan McVeigh, do we still have you with us?
Yes, I'm here.
Good. Should I please?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you hear me okay, Ms. McVeigh?
Yes, I can.
Okay. And you're the ongoing specialist for the children?
Yes.
Okay. And how often do you meet with the family?
I meet with them monthly and service providers will meet with them more frequently.
Okay. Are there any services that you're providing to this family?
The one service that they did agree to participate in is the safe care services. That would be a weekly home visit.
Okay, and safe care, what exactly is that?
It's a parenting program where they have different modules for the different types of parenting. Usually they come to the home to work with individuals.
Let's see, did you have opportunity to speak with Robin about perhaps a safety plan regarding refraining from marijuana or alcohol use while?
Yes, we discussed it at the home visit that I conducted.
And what was her response to you?
Said that she was not using any substances.
Okay, and did she agree to participate with any drug screens at all?
She did go to LDC.
Okay, and when was that call?
Excuse me?
Do you recall when that was?
The date? I can get it in just a second if you need the date.
Sure.
Just a second. The drug screen was on 10/11/24.
Do you have the results of that screen?
Yes, I do.
What are the results?
She was positive for THC and Suboxone.
Okay. Is there anything else in regards to a safety plan that you went over with the family?
I did discuss with Miss Hardy about if she was going to continue to use substances to not be breastfeeding her child. And she was observed to be giving the child breast milk when I was present, and she said she had not been using.
I see. Have they been cooperative with you in regards to following any type of safety plan or any type of suggestions?
They did cooperate with a home visit, and they said that they would participate in safe care services. But as far as the safety plans go, especially after getting this drug screen result, it doesn't look like she's following the not using part of the safety plan.
Was Tyler present when this was discussed?
No.
Okay. There were opportunity to speak with Tyler regarding any safety plan?
No.
Okay. Thank you. I have nothing further now.
Mr. McFarland?
There's a possibility that if my client stopped when asked, that if she had been a heavy user, that it would still be in her system based upon your last test, right?
I don't know how long ago her last test was.
How long does it remain in her system with your testing?
I don't know, because this is an LDC drug test and we don't typically use these. I would have to call the company and ask them.
So you don't know if the positive test result was because of active use or residual from prior use, correct?
I don't know that.
Fair enough. Nothing further.
Ms. Dumont?
Ms. McVeigh, were you only unable to speak with Mr. Long because he was at work?
Yes.
And you don't have any concerns with his parenting at this point, is that correct?
Yes.
Nothing further.
Ms. Underwood?
Miss McVeigh, was the youngest child recently seen at the pediatrician for a cough or a cold?
Yes.
Okay. And did the parents fail to take the child to the follow-up visit?
There was a well child exam that was 10, I believe it was 10/7 that it was supposed to occur. It did not occur. The doctor's office reported it was a no call, no show, but it's rescheduled for 10/22.
Okay. Since you have become the ongoing worker in this case, what would you say that mom's level of cooperation has been?
She's been responsive since I've been working with her. Okay. She's answered text messages, she's answered phone calls, she participated in a home visit, and she participated in a drug screen.
And what has dad's level of cooperation been at this point?
I haven't been able to contact him yet.
Have you made attempts and he has not reached back out, or have you not attempted?
I
Just
have
to
not
clarify.
attempted.
Okay, and how long have you been assigned to this case?
About 2 weeks or 3 weeks.
Okay. Thank you for your clarifications. No further questions.
Any redirect?
Redirect, thank you.
Any recross?
Just one. Why was there no attempt to contact father for 2 weeks?
I haven't contacted him for 2 weeks. He was just seen. In my case, we're required to see the parents monthly in the home, and he's already been seen in the home once monthly.
Thank you. Okay, now I understand. Nothing further.
No questions, Your Honor.
Okay, any recross, Ms. Underwood?
Oh, Your Honor.
Okay, anyone else you'd like us to hear from, Mr. Trevor? Or Mr. Tipton?
No, Your Honor, Department rest.
Okay. Testimony today, Mr. McFarland.
No, Your Honor, the burden's on the agency.
Thank you. Ms. Dumont?
No, Your Honor. Thank you.
Ms. Underwood? Any witnesses?
No, Your Honor.
Very good. All right, comments in closing, Mr. Tipton?
Yes, thank you, Your Honor. I ask the court to find that as probable cause, and make a finding that probable cause exists that one or more allegations in the petition is true. The testimony from Ms. Trout was very thorough. You have indications of obviously drug and or alcohol use by the mother while she's nursing the child, RL. We have concerns about her appearance during one child well visit with slurred speech, failure to keep her eyes open. It was the same type of behavior when my client visited her. It prompted her to do a drug screen, which was positive for marijuana and alcohol. And according to the petition, according to forensic fluids, that someone would not test positive for alcohol if it was above the legal limit. In regards to the father, I think we have some minimizing of the situation of the drug and alcohol use while the mother is nursing his child. And even though, you know, he works a lot and I can appreciate that, it was a little bit of a failure to protect because there was, you know, the concerns that the agency brought up to him, or simply purchase some formula for the child until we have a situation where the mom is no longer using marijuana, or at least testing negative for marijuana. And if she's not, if she still maintains that she's not using marijuana, we have a test here which she can take today to you know, convince the court that she's no longer using. I think that there's been enough evidence to be presented, Your Honor, that the court can find probable cause and authorize this petition to be filed.
Mr. McFarland?
Well, Your Honor, taking a look, so we have marijuana in the meconium of the child. We have to link that to a risk of harm. There are no records that if my client was using marijuana during the pregnancy, that caused any harm to the child. So that's not a risk. Any ongoing issues? Well, we don't even know what level, based on the testimony of the worker, if my client was using marijuana, that would cause her not to have capacity or would impair her. We don't have that. I don't see that in the drug test results here. We need something more positive than she was using. So what if she was using? You need some tie that there's a risk of harm to her parenting ability, her capacity. We don't have that here, Your Honor. Once again, same with the alcohol. Tested positive for alcohol. Now, we have them saying that it had to be this level, but we don't have any definitive results that it was 0.07, 0.04, 0.09. We don't know. It's not here, Your Honor. And My client was not offered a test to have that same sample retested. And if it comes, the results come days afterwards, what good does that do her? What level, if my client is currently using marijuana, does it take for there to be a risk of harm to the child? Once again, we don't have that in here. There was no testimony to that. You can shout wolf, you can say there's a fire, but we don't have any concrete numbers in this petition that would say her behavior is of risk of harm. We don't have any testimony today, nothing in the petition, but there was not another adult that would be able to watch the child. As a matter of fact, we have the contrary. We have the worker testifying that there was evidence, testimony that my client's mother was present. So even if she was using, we don't know that she was in charge of the child, that there wasn't another responsible adult. We don't know that. It's not in the petition. It's not in the testimony. I think this is such a weak case, Your Honor, that they have not met their burden of proof. We ask that this case be dismissed.
Comments, Ms. Dumont?
Yes, Your Honor. From our perspective, there's no instances on Mr. Long's behalf of neglect. He works to support his family. That he has no marijuana usage or alcohol consumption, and the department isn't concerned with him doing that, so much so that they don't drug screen him or contact him. There was also testimony that there wasn't any issues with his parenting skills at this point. So with regards to Mr. Long, we would ask the court to find that no probable cause exists and deny authorizing the petition on his part.
Ms. Underwood?
Your Honor, I think that the key word that I keep hearing here is minimizing. It seems like the parents are minimizing potential issues that the department has been finding. The attorneys are minimizing the potential harm that these children, especially the youngest child, face. Any positive test of marijuana in a child is too high. No child should be testing positive for drugs. And the fact that mom has taken enough or used enough for it to pass through to the child is unacceptable. There are two times where Miss Hardy appeared to be impaired. And again, the drug screens reflect that she did test positive for THC, and one of those she tested positive for alcohol, which be required, or it would need to be at least 0.08 or above in order for that positive test to even come about. So that is another, I believe, piece of evidence that supports that Miss Hardy is not making choices that are beneficial to the child. And in fact, there is a substantial risk of harm if she is under the influence of alcohol or marijuana while she's nursing an infant and caring for an infant, for that matter. The fact that there are several well checks and visits that have been no call, no showed, and not attended, that reflects on not only mom, but also dad. I understand that dad works, but he is responsible for this child just as mom is. And if she's unable to make those appointments, then he needs to make sure that that child can make it to those appointments. Also, the fact that dad is minimizing mom's substance use is very concerning. And while I understand he needs to work, there needs to be somebody home to care for that child while he's unable to do so. I believe that that is also a concern and rises to probable cause to support Your Honor authorizing this petition. The lack of cooperation with the department also is the reason why this case was, or this petition was filed in the first place. The petition does state that there was several attempts made to contact both parties with respect to this case, and there was very little lack of cooperation prior to the petition being filed. So for those reasons, I believe that there is substantial risk of harm to this child. There's enough, there is probable cause to support authorizing the petition, and I would ask that Your Honor take jurisdiction over these children at this time. Thank you.
Thank you. Well, the court finds all interested parties were given notice for purposes of the preliminary hearing scheduled for today. It was adjourned to make sure that both parents had the opportunity to meet with their attorneys and go over the allegations in the petition. And of course, we had the presentation of the testimony of Ms. Hannah Trout, our investigator in this case today, to assist the court in determining whether or not there's probable cause that there's been a violation of the statute MCL 7128.2B1 or 2 or both, that the children's parents, when able to do so, neglected or refused to provide proper care, proper or necessary support, education, medical, surgical, or other care necessary for the health and morals of the children, or is subject to a substantial risk of harm to mental well-being, abandoned or without proper care and custody. 2, ask the court to determine whether there's probable cause that there's been a violation by way of the children's home or environment with the respondent parents by reason of neglect, cruelty, drunkenness, criminality, or depravity, creating an unfit place for these 2 juveniles to live in. I do find that there is probable cause for a violation in this context. We have, even if I were to apply the rules of evidence to this case, we have admissions from mom that she has used THC, that she is breastfeeding. Those admissions were made directly to the investigator. She clearly supplied the information that she has a prescription for amphetamines and THC. So the allegation that there's no harm that can be had from individually these substances was contradicted by some of the testimony that we heard Ms. Trout discover, but also one or more of these substances in and of themselves may pose a risk of harm to her or her child that she's breastfeeding, but together is certainly another thing. There's certainly nothing showing that it's safe to combine things like THC and Suboxone and Adderall and alcohol. I do have pretty definitive evidence that she has been drinking. We have a test that, and Forensic Fluids will have to show this at the trial potentially, but their tests are designed purportedly to allow only a positive showing of alcohol if someone is above a 0.08. And it did indeed demonstrate that Ms. Robin Hardy's blood alcohol level was above that level at the time she tested. She also had THC in her system at that time. So it appears the drug tests are intermittent at best for the things that she is prescribed, and that at worst they're combining with things that aren't something clearly that she's cleared with her doctors to combine, and then she's breastfeeding. So that's definitely presenting a risk of harm to the infant, who was also born positive for THC. I would love to have some additional testimony at trial on the effects of THC on a child. I know in past cases we've heard at a minimum about that creating developmental delays, creating problems with lactation, with latching for breastfeeding. And I know in older children, there's some studies out there as well. So do we have definitive proof that THC is bad for infants? No. Is it pretty common sense? Yes. Is it also pretty common sense that combining THC, alcohol, amphetamines, and Suboxone is a bad idea? Absolutely. Thank you. So for all those reasons, I do certainly find that there is a violation by a probable cause standard, that this mom is making choices right now that are placing her children at a risk of harm, both because of physically what she's feeding the youngest one, and secondarily because of the state that she's in when she's trying to parent. We have the firsthand observations of Ms. Hannah Trout, that she was unable to keep her eyes open. She's had slurred speech. Apparently, Tyler has admitted that she acts like this, always looks like this, or acts like this. So I have concerns about his ability to understand what a risk it is also to leave his children in the care of someone who is intoxicated to that level, combining intoxicants and then attempting to watch 2 young children, an infant and a 5-year-old. I would note, and this wasn't specifically explored, but it does indicate that there is a potential charge for Mr. Long from 2018 for misdemeanor while operating while intoxicated. And I would certainly hope that he's also not imbibing and using substances when he is home to try to help watch the children. And I'm not reaching that conclusion at this point, but it is concerning that he doesn't think that we need to safety plan around alcohol, even potentially when confronted with the information that the woman who's in charge of watching his children is registering for 0.08 VAC or above, she wouldn't be able to operate a car in that condition legally. And so certainly, I don't know how we can expect her to be able to keep up with a 5-year-old or be a healthy person to feed an infant. So there's a lot of issues here, certainly that arise to at least the level of probable cause for the court to take jurisdiction of the family and require them to start taking part in services. But we'll have a bench trial wherein we'll have a better presentation, a clearer presentation of evidence as necessary. And in the meantime, I certainly hope that the family does engage in some services. The one or more of the children is qualified for early on. Those things need to happen. They need to make it to their well child examinations with a sober parent at the wheel and at the helm of parenting. That's what is necessary here. And that's what we're asking you to do. So I hope that you'll take advantage of the opportunity to do some voluntary services. And I'm happy to set our next couple of dates. But yes, I do find probable cause of a violation of both statute subsections 1 and 2 in this case, based on the presentation of evidence today. And I am authorizing the petition for I know jurisdiction moving forward. And let's talk about some dates. Find your trial date first, and we'll work backwards from there. We're getting into the holiday season, which is never good for purposes of scheduling. Let's see. Sorry. I do have Friday, November 15th. We could start at 10:30, or we could start in the afternoon. If you don't want to use Friday the 15th, I have some options for, I could do a remote hearing the Wednesday before Thanksgiving on the 27th, or a remote hearing on Monday the 2nd or Tuesday the 3rd of December. If anybody has a preference on those dates.
Available 15th in the afternoon.
I have nothing scheduled.
15th in the afternoon.
I'm unavailable, Your Honor, on the 15th in the afternoon. I have a trial before Judge Olsaver.
All right. Well, let me put it to the attorneys for the parents. Do you want to consider a remote trial, or would you prefer to be in person?
Well, I prefer in person, Your Honor, there for my client can talk to me, communicate, shift notes. It's not as easy to do by Zoom, so.
Yes, I do as well. I just want to make sure you have that option. I can give you a backup to a juvenile jury trial Friday, December 13th.
I don't mind. The only issue is I know that the agents will be bringing witnesses, it sounds like, so stand by. I'm fine.
Is that in the afternoon here?
I could go as early as 10:30, or I can start in the afternoon, whatever you, I mean, if you think you only need a few hours for it, then we'll start in the afternoon.
We can break for noon as we have a staff Christmas potluck here, which is important.
Right, I don't want to.
Okay, well, I think we can bump it to Monday if you want to do Monday instead.
16th would be perfectly fine by me.
Yeah, sure.
16th is fine. Thank you.
Not sure we'd have Mr. McFarland's full attention after a potluck.
Yeah, I may be in a sleep coma. That'd be a good way of putting it, yes.
Morning or afternoon is fine. 16th.
Okay, I can do 10 o'clock on the 16th.
Fine by me, Your Honor.
Ms. Underwood, is that all right with you?
I would prefer afternoon, but I could make 10 o'clock work if possible, if necessary.
All right, well, I think the main question is how many witnesses are we gonna have? Do we know?
3, my client and her 2 parents, Your Honor.
Approximately 4.
All right, we better start at 10, Ms. Underwood.
That's fine. I can make arrangements.
All right, thank you. The other thing is I'll schedule a pretrial and I'll ask everyone to have your witness and exhibit list filed and exchanged by that point, so that we can have a better idea And when you do your witness list, please give us just a short indication of what each witness would be testifying to, so that all of us can prepare and I can look at the docket to make sure that we have enough time. So we're starting at 10 a.m. on December 16th for the trial. Backing up to look for a pretrial. Mr. Tipton, is there a time where you're already going to be in town you'd like me to consider? I don't know what cases you're on.
I don't think I have any cases with you.
Okay. All right, all right. How about? Well, I could do 1 o'clock Monday, November 25th.
It's fine with me.
I can do that.
That's fine.
Okay, so November 25th at 1 o'clock for our final pretrial. And as I stated, I'll ask you to have your witnesses and exhibit list done by that point. All right, it's only a request for in-home jurisdiction. The court's not been asked to remove the children immediately, but please be aware that obviously you'll have the opportunity to continue working with Child Protective Services. And I think you've got an idea of the concerns that were expressed today, and I hope that you'll take advantage of that between now and when we come back. Unless there's any questions, that's all for today. Thank you. Hey, we're here this morning continuing from a hearing on Saturday. There was a petition 2 filed on Friday afternoon alleging some pretty serious things as it relates to injuries on the youngest child, and I'll be going through that here in a few minutes after appearances.
Good morning, Your Honor. Nicole Underwood, lawyer guarding ad litem for the minor children.
Good morning, Your Honor. Troy Tipton, appearing on behalf of the Department of Health and Human Services.
Ken Trout with DHS.
Michael McFarland, representing Mother. Please identify yourself.
Robin Hardy.
I'm Lee Heist. I'm filling in today for Katrina Dumont, representing Tyler Long.
Thank you. I confirmed with both of your clients yesterday, counselors, that Saturday, I'm sorry, that neither of them had any Native American heritage or any reason to believe that they qualified for evaluation in that respect. Is there any different information on that this morning?
I do, Your Honor. My client's father indicates that there is some Native American heritage. It's so far back, but still, I think we need to reveal that to the court.
Thank you. All right. Ms. Trout, we'll trust you to follow up on that.
Your Honor, may the record reflect that Tyler Long is here with me today, and I have no different information today about the Native American.
Thank you. All right. The other reason we adjourned from Saturday was, of course, to allow Mr. McFarland to join us on behalf of Ms. Hardy, who requested that the petition be read into the record. So I'm ready to do that now, if that is still your position, Mr. McFarland.
Yes, please, Your Honor.
All right. So why don't we just take care of that right off. It's petition 2 regarding the 2 Long children, indicating that Tyler Scott Long and Robin Lorraine Hardy are the legal parents of these 2 minor children. There is an indication that there's one other case that applies to this family regarding the older child. But other than that, there does not indicate any additional cases, and that's page 2, paragraph 3. Paragraph 4 indicates the violation of the statute under MCL 712A.2B. Specifically, the paragraphs relevant are the parent or other person legally responsible.
Your Honor, my client indicates she could.
Sorry.
Okay, I'll try to speak up.
Thank you.
The allegation of the violation of the statute is that the parent or other person legally responsible for the care and maintenance of the children when able to do so, neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the children's health or morals, or that he or she has subjected the children to a substantial risk of harm to his or her mental well-being, or he or she has abandoned the children without proper custody or guardianship. The other paragraph applicable indicates an allegation that the home or environment, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, guardian, or non-parent adult, or the custodian, is an unfit place for the children to live. Thank you. Paragraph 5 is checked, indicating the reason.
Your Honor, I'm sorry, but my client does have a learning disability. She's asked if you could slow down just a bit so she could process it.
I'm sorry.
You'll have some time to go over it with her after the hearing, Mr. McFarland. There's 6 pages of this, 4 pages to the addendum and 3 pages to the form, so technically 7. So I am reading it into the record for her benefit. But we only have an hour this morning, and I'll welcome you to chat with her about it at a later time as well.
Absolutely.
Because I'm not gonna take the time to
Okay.
go through all of the allegations and answer questions. That's why she has you.
No, that's not what she wanted.
Okay.
Thank you.
Paragraph 5 indicates the reasons why it's contrary for the welfare of the children to remain in the home, and that is in the first amended petition attached. Paragraph 6 is checked, indicating reasonable efforts made to prevent the removal of children were included in the amended petition, which is the attachment. Paragraph 7 also indicates specific allegations are contained in the amended petition, which was attached. There's a request to issue an order removing the children from the care of the parents, which was authorized again last Friday night. The confidential case inventory does reference the other DC case 2019-46309. And the addendum indicates as follows, beginning on page 1 of 4, addendum to petition for emergency protective custody and jurisdiction as to responding parents, jurisdiction and venue. 1, Robin Hardy is the biological mother of the subject minors. 2, Tyler Long is the legal father of the minors, Aaliyah Long and Rowan Long. Paternity is established by an affidavit of parentage, AOP number 2024-024463 and 2019-007850. 3, the subject minors may be members of, eligible for membership in a Native American tribe or band. Robin Hardy was asked and indicated she and the subject minors have Native American heritage. Subparagraph 3A, based on the information provided by Robin Hardy, a DHS 5598 was completed and mailed to the BIA, which is the Bureau of Indian Affairs. Completed certified mail receipts are attached, but no responses have been received. Paragraph 4, the subject minors are residents of Lenawee County, Michigan. The subject minor RL is currently located at Mott's Children's Hospital. The subject minor AL is currently at Clinton Elementary School. Paragraph 5, the incident of alleged abuse or neglect occurred in Lenawee County, Michigan. Factual allegations. 6, neglect, physical and medical. A, on or about 11/20/2024, CPS received a complaint alleging concerns of failure to thrive of the youngest child of Robin Long. This was not assigned for an investigation, but sent to the ongoing worker to address. B, on or about 12/12/24, CPS received a complaint alleging physical abuse of the youngest child by Robin Hardy and Tyler Long. C, that child was evaluated at the University of Michigan Mott's Child Protection Team. D, it was noted that the child has a significant medical history of prior poor weight gain. At his 2-month well visit, he was 3 months old, and that's in parentheses, on 11/12/2024, Dr. Bakshin noted that the child had skin lesions on his abdomen, back of his left upper arm, and left side of his back below his shoulder blade, concerning for bruising. E, the child subsequently switched to a PCP at ProMedica Physicians Health Specialist of Lenawee. At the child's first visit to the new PCP, he was found to be underweight and have poor weight gain. F, the child returned to Trinity Health and was evaluated by Dr. Bakshin for his 4-month well visit on 12/12/24. Dr. Bakshin noted that the child's prior concerning skin findings had resolved, supporting that these previously noted skin findings were most consistent with bruising. The child was then referred to Mott's CES due to suspected physical abuse and further evaluation and management. G, a skeletal survey was completed which identified a healing left mid-posterior 9th rib fracture. No drops, falls, or other traumas sustained by the child were reported by Ms. Hardy to explain the child's rib fracture or prior bruising. Furthermore, Ms. Hardy denied that neither of the family's 2 dogs or the child's 6-year-old sister could have harmed the child in any way. H, it was noted by the doctor that the child's fracture is a fracture type that is highly specific for physical abuse. The child's rib fracture is healing, indicating that the fracture is at least 10 to 14 days old. The child's rib fracture is not a birth injury. 2, Tyler Long has no CPS history as an alleged perpetrator. 3, Robin Hardy has the following CPS history. Subparagraph I, 3/6/2019, category 4 for physical abuse. Victim was the older child of this case. Perpetrator was identified as Robin Hardy in Lenawee County. Subparagraph 2, 9/22/2020, a category 3 open and closed for improper supervision. Victim again was the older child concerned in the jurisdiction of this case here. The perpetrator was found to be Robin Hardy in Lenawee County. Subparagraph 3, 10/26/21, a category 3 case, physical neglect, improper supervision. Victim, the oldest child, AL. Perpetrator, Robin Hardy, Lenawee County. 4, subparagraph 4, 9/2024, category 2 for physical injury, threatened harm of placing a child at unreasonable risk. Victim, the youngest child in this case. The younger child, and the older child. Perpetrator identified as Robin Hardy by Lenawee County. Subparagraph 3B, Tyler Long has the following criminal history. Subparagraph I, January 24th, 2012, ordinance violation, assault or assault and battery. Pled guilty, 18 months probation, fines and costs. Subparagraph 2, 11/7/13, attempted misdemeanor police officer fleeing 4th degree vehicle code. Pled guilty, 24 months probation, fines and court costs. 3, 9/23/13, misdemeanor larceny, $200 or less than $1,000. Pled guilty, 24 months probation, 10 days in jail, fines and court costs. Subparagraph 4, 11/15/18, misdemeanor operating while intoxicated. Pled guilty, 12 months probation, fines and court costs. Subparagraph C, Robin Hardy has the following criminal history. I, 6/22/23, misdemeanor assault excluding sexual. Statutory citations. 7, required petition. This is a mandatory petition under Child Protection Law, Section 8D1E, MCL 722.628D1E. Paragraph 8, statutory grounds for adjudication. Based on the above stated allegations, jurisdiction is proper under the following subsection of MCL 712A.2B. The child is under the age of 18 and A1. The children's parents, when able to do so, neglects or refuses to provide proper or necessary support, education, medical, surgical, or other care necessary for the children's health or morals, or is subject to a substantial risk of harm to their mental well-being, who is or are abandoned by their parents, or who is without proper custody or guardianship, and or D2. The children's home or environment with respondent parent by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent is an unfit place for the juvenile to live in. 9, statutory grounds for removal. Based on the above stated allegations and pursuant to the following subsection of MCL 712A.13A, removal of the children from the respondent parent's custody and care is necessary. And A, 3, releasing the children to the non-respondent parent under the supervision of the department is reasonable and necessary for the children's physical health or mental well-being. B, 4, order the parent, guardian, custodian, non-parent, adult, or other person residing in the children's home to leave the home and accept as court orders not to subsequently return to the home as all of the following exist. 1A, a petition alleging abuse of the children by the parent, guardian, custodian, non-parent, adult, or other person is authorized under MCL 712A.13A2. B2, B, there is probable cause to believe the parent, guardian, custodian, non-parent, adult, or other person residing in the children's home committed the abuse. B3, C, the presence in the home of the person alleged to have committed the abuse presents a substantial risk of harm to the children's life, physical health, or mental well-being. C, 9, placement of the children into foster care is necessary. A, custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. 2, B, no provision of service or other arrangement except removal of the child is reasonably available to adequately safeguard the child from risk, as described in subdivision A. 3, C, continuing the child's residence in the home is contrary to the child's welfare. Roman numeral 4, D, consistent with the circumstances, reasonable efforts were made to prevent or eliminate the need for removal of the child. Roman numeral 5, E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. Relief requested. 1, authorize this petition for emergency protective custody and jurisdiction as to respondent parents, Robin Hardy and Tyler Long. 2, issue an order removing the children from the care and custody of their parents, placing the children in the care and custody of the department. 3, take jurisdiction over the child pursuant to MCL 712A.2B1 and 2. And 4, set this matter for an adjudication trial. Respectfully submitted on 12/13/24 by Troy Tipton and Hannah Trout for Michigan Department of Health and Human Services, Lenawee County. All right, counselors, your clients both confirmed also on Saturday that they had received a copy of the petition. Are there any other cases other than the child support case reference for the older child, like a guardianship or child support, custody, any other cases that concern these children?
Client indicates no.
My client is not aware of any other case.
Thank you. All right, you were both clients were informed that they are entitled to an attorney, which is why we have 2 attorneys from the Public Defender's Office here today. If either of you wish to retain your own private attorney, you're always be able to do that. That person will just have to get a hold of the attorney from the Public Defender's Office to ensure that they have what they need to perform as your new counsel. You also have a right to a trial by judge or jury on the allegations in the petition for purposes of adjudication. If you wish to exercise your right to a jury trial, that must be done in writing within the next 14 days. You have the right to seek placement of the children at this time. The right to an opportunity to admit or deny the allegations and make a statement of explanation. The court has already authorized the filing of the petition, and I look forward to any further argument on pretrial placement at this time. Mr. Tipton, has the department's position changed at all from Friday?
No, Your Honor.
All right. Ms. Underwood, if you would please give us any comments you might have.
Yes, Your Honor, thank you. After reviewing the petition and just looking at all the circumstances, I think we have a fine line here between the safety of the children, but also ensuring, I believe that Ms. Hardy is still nursing. So if there's a way that the children, and especially the youngest, can be safeguarded from any other risk of harm, but also be able to continue either providing milk some way for the child, that would be in the youngest best interest. But at this point, I do believe it's in their best interest to be removed until we can further investigate what had occurred. Thank you.
And would you be willing to talk with Hannah Trout on that and or potentially participate in a family team meeting about your concerns?
Absolutely.
Okay. Today, presentation or issues for today, Mr. McFarland?
Your Honor, excuse me. Just wanted to be able to listen.
Yes, sorry, she was.
My client at this point is requesting a bench trial, Your Honor. I understand we have 14 days to change our mind, but at this point, we're requesting a bench trial. We are requesting that the child be returned home. I've been talking to the maternal grandfather, who indicates that there would be an adult other than my client with 24-hour eyes on child, Your Honor. We do have another physician who indicates no issues regarding the malnutrition of this child. We've not explored. We may possibly request an independent examination of the child. We are requesting that the oldest child, who was not found in this case to be injured, neglected, that child be returned home. The mother is our request, Your Honor. We're also requesting the same for the youngest child, with the understanding that there would always be an adult supervisor other than my client with the child. In the event the children aren't returned, my client would like as frequent parenting time as possible with the minor children, I should say. We would suggest that parents would be adequate supervisors is what we're asking for.
When you say parent, you mean the grandparents of the children?
I'm sorry, Your Honor, my client just said something.
That's okay. You asked that the parents be able to supervise. Which
Yes, my client's mother is no longer working, so she's there 24 hours, Your Honor. And then when her father's not working, there are 2 adults in the home. That's true, Your Honor.
All right. I am listening as far as your request for potentially a child abuse expert to be provided to your client. And I am open and amenable to that, Mr. McFarland. I do know that that's been a difficult thing to find in the past.
You realize that.
So I will leave it to the Public Defender's Office to secure that particular expert and bring that person to us for approval as soon as possible. I'm looking at a trial date of February 10th, commencing at 10 a.m. And if you need additional time, of course, we can look at that.
Your Honor, I won't be available that day. If you're okay with the ongoing worker stepping in for me, that's fine. But I will not be available.
And I'm sorry, Your Honor, I do have a scheduling conflict at that time.
All right, I have Friday, February 21st, or the following 28th, if either of those days work better.
I can do either of those.
February 21st is fine with me.
That's fine.
All right, so we'll set the trial then for Friday, February 21st, commencing at 10 a.m.
Did you say 10?
Yes. I can do a pretrial on January 27th. Let's see. Yeah, that's the earliest I could do the pretrial. So January 27th at 10:30 or 11. Let's do it at 11.
Judge, I have an 11 o'clock, but the rest of the day I have open that day.
I do not. Looks like I already have this on my calendar for a bench trial on maybe petition 1
Right,
or
but
Friday, January 24th.
I thought we removed that with the resolution that we had, Your Honor.
Oh, thank you.
Extension of time.
So what I can do is turn that January 24th, 10 a.m. into a pretrial. Is everyone available Friday, January 24th for a pretrial at 10 a.m.?
Yes.
I am not, but given that it's pre-trial, I think the ongoing worker could step in for me for that.
All right, thank you. Who's the ongoing worker?
Megan McVeigh.
Thank you so much. Do we have Ms. McVeigh with us this morning? I don't see her. Okay.
We do. I
Right,
believe
Mr.
she's on Zoom.
Okay, all right. So who would be handling any family team meeting on any issues with regard to visitation and the concerns that the guardian ad litem has expressed this morning about the child's nutrition needs?
I think Megan and I can both kind of tag team on that.
All right, very good. Anything else to add to that request for family team meeting, Mr. McFarland?
Well, Your Honor, yes. There's a school class party for the oldest child. We also have Christmas coming up, exchange of presents, visits. There's birthday, January 23rd, that's coming up. 3rd, I guess. Third. So basically holiday events around the season.
Very good. I did note that they should address parenting time. I would hope that visitation for purposes of holiday would be included in that conversation. But thank you for placing that on the record.
Then our inquiry was, we know the court usually allows at least 3 visits, 2 hours per week. Can you considering or placement?
Okay, do we have a worker that can speak to the initial plan for visitation?
Your Honor, may I articulate just briefly?
Sure.
Sorry.
No, that's all right. Go ahead.
You know, I believe in this case, there is a less restrictive environment for the children to live in. I'd ask you to consider that in the petition on page 3 of 4, 9A indicates that the statutory ground for removal is necessary, but it anticipated releasing the children to the non-respondent parent under the supervision of the department. It is my understanding that in the underlying petition that had been filed since September, that this father was released as a respondent in that case. I would like to indicate that he has his own independent housing and employment. He would like you to consider releasing the children to both him and the children's mother so that they would move this independent adult in so that there'd be a person around the clock. They have family support. At this time, the 2 children are placed with the maternal grandparents who have the ability to do this, although we all know that a movement of the children from their home in the middle of a school year near the holidays adds extra trauma. I would ask you to consider that my client, the father's father, took the children to school this morning. You know, there is this cooperation, there is this support so that the children have been under supervision since September 24th of 2024 at least, and the ongoing worker, Megan McVeigh, has approved the home. There is this allegation of these injuries and a break, and there are also defenses to that. I would ask you to consider that although there is not a response at this time that makes sense about how those injuries could have or would have happened, this is also very new, and these folks need time with their attorneys to talk back through what does and doesn't possibly contribute to these injuries. And we had an ongoing worker in and out, and these injuries are alleged to have been up to 2 weeks old, and they're 85% healed. There's a lot of medical information for the attorneys to go through, an expert to look at it. And in the meantime, I don't know that there's a reason the children can't continue in the least restrictive environment in their home. Further, although with reservations, my client is willing to have the children with the mother removed from the home if that makes any difference. This is what I note. Mother was a respondent on the underlying case, and she was doing well, and she anticipated that because she had a THC, had used THC, and her levels were continuously reducing, that she would be released under that too. So I don't mean to indicate that she's a perpetrator, so she should be out of the house. But as an unmarried couple, he does own the house, and he is employed, and he would abide by any of the rules needed. So with that presentation, then we were going to talk about visitation next. Thank you.
My client would remove herself from that house, sir.
Well, before I forget, the issue of marijuana use that was raised in the first petition does affect the court's position on breastfeeding, Ms. Underwood. So if you could please make that part of the conversation during the family team meeting. I am not generally inclined to allow a parent to breastfeed a child who is testing for high amounts of, or any amounts of, really, THC in their system, considering the possible effects of that on a newborn child. And in this case, we have an injury on top of that, so I would not be inclined to allow the mother to take that risk. So please take that into account when you're at the family team meeting. I'm sure there's drug testing that can be done in order to really inform better about that point. But I know I've announced that on the record in this file before.
If I may, Judge, I know that Ms. Hardy had been taking regular drug tests in order to show that her levels were decreasing, that she hadn't been actively using, which is, again, I have not had an opportunity to talk with ongoing worker about the status of those, but that can all be explored on the meeting.
Thank you. All right. So then visitation for sure will be something that we'll ask the department to do within the next 14 days on visitation, and to allow the parties to look at that between now and then. On the request for in-home jurisdiction, I would note that on this petition, both parents have been named as respondents, and the court did authorize that petition. So before I turn it over to Mr. Tipton, I do want to recognize for the record that Tyler Long has been recognized as a respondent in this petition, in addition to mother being recognized as a respondent under the current allegations. But as it relates to the request for in-home jurisdiction, Mr. Tipton, would you like to respond?
Your Honor, the department, I would object to in-home jurisdiction. As the court indicated before, the department did, make efforts to keep AL and RL home, and that was the whole purpose. Now we have these new allegations, well, at least one of the allegations, but of RL not thriving, but also we have allegations of unexplained serious injuries. So I do believe that placement of the children and with the relatives is the least restrictive environment at this time.
Did you want to say anything on that request, Mr. McFarland? I did hear your remarks that your client would be willing to vacate the home, but both parents are indicated as respondents.
Well, Your Honor, there is no allegation
that the maternal parents were in any way involved, implicit, were responsible for the alleged injury. So do you think that that would still be a viable option as to maintain stability for the kids so they're not traumatized by it? Let me just inquire if there's other family that might be considered. My client is indicating that the paternal grandfather would be a possible family placement rather than foster care. We'd like to have that explored.
Ms. Underwood, did you want to say anything about the request for in-home jurisdiction?
I don't think that in-home jurisdiction is appropriate at this time. Like I said, I think the allegations are pretty serious and those need to be explored further before the children are in home. I would be open to hearing a little bit more about if Ms. Hardy were to move to somebody's home with the children or have that closely monitored, but I'd really like to err on the side of caution at this time based on the additional allegations that have been brought forth while the children were already under the care and supervision of the department. Thank you.
I can't address that, Your Honor. If the court would just allow me a minute. My client would move out of her parents' house, and she's not living there now, and she would agree not to enter without permission of the agency. So therefore, there would be a permanent caretaker there in the maternal grandmother. The maternal grandfather be there. This is the residence the kids are aware of. My client will not be there. And I can have grandfather testify today under oath that he would abide by that court order, Your Honor.
All right, Mr. Tipton, I would like to hear a little bit about the department's decision to utilize, it sounds like unrelated foster care rather than a relative placement. Is that what's happening?
It was my understanding.
Okay.
Oh, it was my understanding that they were placed with relatives, Your Honor.
That's what I thought too.
Yeah.
Right, but we're indicating that this would be another option. That's preference for my client would be first her parents and then the paternal side of the family.
Is your client residing with her parents?
She is not, Your Honor.
Okay, I just wanted to be clear that at this time, the court is not authorizing that. Both children, as I understand it, are already placed with her parents. So
That's fine.
that's where they're going to stay, assuming that the relative placement is prepared to follow the directives and orders of the court, as well as cooperate with the Department of Health and Human
Thank you. I
Services.
thought the foster care placement removal was on the table. If it's not, then thank you.
Okay. This was just a removal from the parents.
Just gonna say.
Okay, right, Mr. Tipton? Am I missing something?
No, Your Honor, that's correct.
Very good. Okay, well, that's good. Relative placement obviously has priority. Relative visitation is an option under the manual. Obviously, that's something that's being requested, so we'll add that to the list of things for the family team meeting. Breastfeeding and nutrition for the youngest child involving the mother if possible, given drug screens that allow her to support in that way. Visitation for the parents, and then also visitation for relatives should be addressed in that family team meeting. And I look forward to the updates at the pretrial. I do agree, based on my review of the petition, and understanding that this was initially an in-home jurisdiction case that looked like it was resolving the initial allegations of marijuana use by mother had been resolving, which was great progress. And we were looking at dismissing the case. However, the allegations in this petition are serious. Obviously, there's a very young child that has injuries very indicative of abuse that have been evaluated by an expert. I look forward to appointing an expert to review their work as necessary. But those injuries did occur while the parents were under the jurisdiction of the court. They had the support of the Department of Health and Human Services. So I cannot find at this time that placement with the parents is adequate to safeguard against a risk of physical injury and injury to the mental health of the children based on those dynamics in the home. The injury of one child can easily be indicative of parenting that applies to all the children in the home, including the sibling that was living with the parents. So for all those reasons, I am denying the request for a no visitation at this time. All right, if you need anything else between now and when we come back, I am obviously available to all of you for any filings. Is there anything else for the record this morning?
No,
No, Your Honor.
We are on record this morning as it relates to a pretrial on petition 1 and petition 2 for both parents. Petition 1 appears to concern just mom. May I have the names of our participants, please?
Good morning, Nicole Underwood, lawyer, guardian ad litem for the minor children.
Good morning, Troy Tipton, appearing on behalf of the department. We have Megan McVeigh, excuse me, ongoing CPS investigator. To my mind.
Megan McVeigh from the department.
All right, and we have Ms. Conrad, are you handling the foster care services on this?
Good morning. Yes, I'm the assigned foster care worker for the case currently.
Okay, thank you. Go ahead.
Good morning. May I please the court, Brandy Thompson with and on behalf of the respondent mother, Robin Hardy, who is also present and seated to my right today.
Name for the record, please.
Robin Hardy. Kindergarten and do monitoring for father Tyler Long.
Tyler Long.
Thank you. All right, any preliminary matters as we prepare for trial on 2/21 of 25?
Your Honor, I do have two doctors that I subpoenaed for the case. And I'm asking for the parties' consent for them to testify via Zoom. And if that's the case, then I would prepare a stipend order. If not, then I'll just file a motion. You're the case, here before our trial date on February 21st.
Okay, Ms. Thompson, your position?
The only concern I have, Your Honor, is that I am waiting on some medical records still to send to an expert. I'm a little concerned about timing to be able to get those scans in, to send them to my expert, to have my expert review them, and then be ready for trial on the 21st. I understand that Mr. Tipton has requested those. I don't know if we have a date certain that we're gonna have those. So that therein is my concern about being ready to go on the 21st.
Well, I was told that the records were mailed to my client from the hospital. And I assured all parties that once I received them, I will personally pick them up from my client and get them to the attorneys as soon as I can. I'm sorry, I don't have a date certain that they would be, that the department would receive them via mail. So I think that there will be enough time, Your Honor, for the all experts to review those skeletal surveys. The other medical records I've provided already.
Very good. All right. There was a bit of confusion too, Ms. Thompson. So in your pleadings, you requested a jury trial, but then you also indicated a bench trial. So what is the preference of your client as it relates to jury or bench?
I believe that I just requested a judge demand, but maybe something got mixed up.
Well, there was a judge demand and a jury demand on page 3, beginning with your appearance.
Yeah, we just, some courts have referees preside, and so that we were just requesting for a judge to hear over that and a jury demand. So yes, we have requested a jury demand. My client is willing to proceed forward with that.
So you want a jury trial?
Yes.
Okay, that's what I wanted to clarify, because it doesn't look like we'll have enough time on the 21st if a jury trial is what's requested. I usually plan those for 2 days so that we can get all the proofs in and then invite the jury back for deliberation the next day as necessary. And especially if we're going to have a couple of different experts, I don't think 1 day would be enough time. So that was the other reason. And then there's 2 petitions as it relates to your client, petitions 1 and 2. So are we just proceeding on petition 2, Mr. Tipton, or do you want to bifurcate the proceedings as it relates to those?
We just proceed on petition 2.
Okay. Ms. Thompson, is that any comment on that or argument?
I just want to make sure I have the correct petition that petition 2 that I am looking at. Is that the one dated September 24th, 2024?
Well, maybe Mr. Tipton, you can clarify this for us, because it looks like maybe there was some confusion on the petition numbers.
Only 12/13.
There's one dated, received December 13th, and then September 24th, 2024, so.
December 13th.
December 13th,
Yeah,
okay.
sure.
So it is, I think that's your first amended petition, and it's reflected as petition 2, but perhaps.
First, okay, I see, petition number 2.
I'm not sure that that's actually petition 2, Mr. Tipton. I don't know. It might just be a first amended, but I'll leave you to that, as long as we all know which one we're proceeding on.
Okay.
That's okay with me. So the one filed December 13th, 2024 will be scheduled for jury trial then. All right, so your options are to keep the 21st, and then your jury will have to come back on the Monday after that, or if you want to look at different dates, or if you're considering an adjournment based on your concerns about the expert testimony and the availability for review of those records, you're not looking at time until April 7th and 8th this year. And that would, you would be a backup to a delinquency jury trial. Would be the first available 2-day spot. And I can try to move a few things around here and there as well, but that would be the first available.
And Judge, I'm on that delinquency trial and I've been talking with prosecutors, so I think that should be off.
Okay.
So April 7th and 8th?
Yes. That would be for both parents.
Okay. That actually works better for me, as I have a bench trial also scheduled for February 21st in Clinton County, but I am completely open April 7th and 8th.
I have no problem with having a jury trial on April 7th and 8th, and I think that we resolve the issue with the medical records and the skeletal survey, and the experts having time to review them.
And I don't think I put on the record that I don't have a problem with Mr. Tipton's experts appearing via Zoom, as I will likely have the same issue. I would just ask that they have the records, just because I've had that issue before, they don't have the records with them. And we've got the records here. I know we can possibly screen share, but just as long as they have the records that they can reference during that testimony, I don't have a problem with that.
Sweet.
So I'm prepared to step in order, Your Honor.
Very good. I appreciate that. All right, should the order reflect then that the parties have agreed, or simply that Ms. Thompson, you're moving for the adjournment officially? Because obviously your clients are the ones who have the right to have the case read within a certain period of time.
I would request that, I mean, I don't know if it's by agreement, but if not, I would request that so that we can obtain appropriate experts and have time for my experts to review everything.
Ms. Dumont, does your client also wish to have an adjournment?
Yes, Your Honor, we have no objection. I think it's in everybody's best interest to get the opinion back from the expert with all of the medical records.
Very well. All right, if that does sound like good cause for adjournment, so we will adjourn from February 21st to April 7th and 8th to allow for jury. Do you want me to schedule it for, I have 2.5 days. I have the morning of the 9th as well, if you think you're gonna have that many witnesses.
I think to be safe, my last one I got going on right now, we thought was gonna take a week and we're on week 2 and still not finished. So 2.5 days would probably, if the court has the time, I guess I would say yes, set it aside, especially with the jury trial.
Okay, we'll go ahead and schedule that for those 3 days then. Do you think you're gonna be done in 3 days?
I hope so.
Me too. If you're not, then I need to know, because the calendar is kind of crazy after that, as far as very busy for my docket.
I guess I don't even know what to say. I think that, I mean, some of it largely depends on how many witnesses Mr. Tipton plans to call. I certainly would have at least an expert, ideally, if we're moving forward. So
I have enough time to clear the rest of that week, if that's what you think would be appropriate or necessary.
Honestly, with a jury trial, I do think that that would not be a bad idea.
Counselors?
And no objection.
No objection.
I have no position on the amount of time.
All right, what are your thoughts about the adjournment, Ms. Underwood?
I think that the adjournment is in the best interest of the children, considering the parties are seeking additional information and records. And this party is seeing the children pretty regularly. So I just think that the department, we need to consider, we don't see any time it's going to look like over the next couple of months. I do believe it's appropriate.
Thank you, appreciate that. Do we need to have a pretrial review?
That'd be helpful.
Well, the department, for funding purposes, I know, and for services, to monitor adequate parenting time and services and supports to the parent and the children, especially with an adjournment out until April, it seems like it might be appropriate. It doesn't look like there's been a report prepared for today necessarily, so I could schedule that out. What are your thoughts, Mr. Tipton?
Yes, Your Honor, I think that's appropriate. Thank you.
All right, so I'm going to schedule the whole week of April 7th then for this trial, and I'll notify my assistant. He can start moving a couple things that are already scheduled during that week, so that you'll have that whole week. And for a pretrial review, how much time do you think you're going to need for that?
Yeah.
And I would defer to the foster care specialist on how much time she would need to prepare that report.
I can consolidate it with a final pretrial March 19th, a month ahead of the trial, which hopefully would give you some time to get those records exchanged and have a better idea of what your time would look like.
Your Honor, I will not be here on the 19th.
Okay, thank you for that heads up.
Through the next week.
What are the dates exactly you'll be out, if you don't mind?
The 19th through the 28th.
Thank you. All right, so then looking ahead of that, can carve some time out. The week before that, Wednesday, March 12th.
I'm available.
At 1:30?
I have a jury trial, Your Honor.
Okay.
Sorry, March 12th.
Monday, March 10th at 9?
So that's when my jury trial starts. So it's expected to go all 3 days.
What about Thursday, March 20th at like 11?
That's when I'll be out.
Yes. Oh, you're out that day, sorry. Okay. Monday, March 30th, while you're out, you said through the 31st?
I should be back. I'll be back that day.
I have Monday, March 31st at 1:30. It's not ideal because it's only a week before your trial, but is that everyone's schedules?
Yes.
Okay, I only have an hour that day, so.
I'm sorry, what did you say?
Monday,
1:30?
March 31st at 1:30?
Yes.
All right, so we'll do our final pretrial and a review on Monday, March 31st at 1:30 p.m. Jury trial forms, verdict forms, jury instructions, and what are your questions? Please have those prepared. I would ask you, in fact, to maybe even have those filed the week before that, by the 24th, so that if there's any issues with those, that can be resolved at the pretrial, so that we can be ready for the jury trial the following week. Unless you need more time than that. So the pretrial order will reflect also that jury instructions, voir dire questions, and voir dire verdict forms will be due March 24th, no later than March 24th. to be, and then any motions that need to be filed or objections that need to be filed would need to be, or maybe we should back it up to the 17th, so you have a week. Because if you need to file an objection to be heard on the 31st, that would need to be filed, obviously, within the next few days. So do you want the 17th, or do you want me to back it up even further to like the 10th? So you have a week or two to look at those and exchange those.
I don't have a preference.
I'm fine with the 10th.
Okay, so let's make
Makes
that due
sense,
date
gives
March
everybody
10th.
extra time.
Okay, so March 10th then for jury instructions, whether questions and verdict forms with
Right.
objections to be filed and set to be heard with the pretrial on the 31st. Final witness and exhibit lists to be filed and exchanged by the 10th as well, please. And if you're going to have records that both sides are using, I know it's a lot easier for the jury and for the bench to have a consolidated binder with those. So I would ask the parties to work together to create something so that we're not trying to figure out, you know, plaintiff's A corresponds to respondents 4. It's a lot easier and a lot better for the jury if that's organized ahead of time. So I'll ask you all to work together on that. And if you don't have that finished by the 31st, you can count on me telling you that that's going to be something you'll have to have, you know, by the end of that particular week. But we can sort through that too if that's going to be an issue. If there's any objections over exhibits. All right. Any other issues that should be addressed for purposes of today's pretrial?
Your Honor, if I could just briefly address parenting time.
Sure.
Currently, right now, Miss Hardy sees the children. She has 3 times a week at 4 hours. One of those is supervised by the department, and then the remaining is supervised by the placement, which is Miss Hardy's father. We would request at this time, this is not a termination petition. The visitations are going well. I haven't seen anything that would indicate that otherwise. So we would request, considering this is, you know, regardless of how we move forward, regardless of whether or not the court takes jurisdiction, that, you know, reunification is the plan. So we would request at least one additional day, 4 hours parenting time.
And Your Honor, we would request the same for Dad as well. They're already executing the same parenting time schedule as
Is that, have you addressed that with the caseworker before today by any chance?
I have not, Your Honor.
Okay, because I think practically
Yes.
speaking, that would probably need to be worked out during a family team meeting. Obviously, Ms. Underwood is gonna wanna look at the burden on the children for that with regard to transportation and some of the other factors that are similarly considered in parenting time cases and civil cases, frankly. And to make sure that that's gonna be in the best interest of the children. Ms. Underwood, do you have an opinion on that right off, or would you need more time?
I think in general, Your Honor, I was able to meet with RL yesterday, the younger child. I know he is still nursing. And so to maintain that, I'm not necessarily opposed to one additional day if the parties are willing to accommodate that, which is family placement. So I think that they would. I know that the older child, AL, is struggling. So it's one of those where would more frequent contact be more difficult because it's more days per week that she's going to have to go back to her grandparents' house and not have her parents there, or would one additional day, you know, be more time for the children to continue bonding with their parents? I think a family team meeting is appropriate, but again, I'm not opposed to considering an expansion, considering we have a few months before the next hearing.
Ms. Conrad, your thoughts?
I will certainly set up a family team meeting for anyone interested in discussing this specific thing further. We can do that quickly via Zoom in the next few days. And my only thought at this time would be, yes, having everyone weigh in on whether the increase in frequency and duration would be confusing to AL, or if it would be helpful to AL, and we can talk about that as a group for sure. Secondly, I would like to just bring up that there has not been, I would like there to be absolute consistent compliance with the drug screens to monitor the THC levels if we're going to be increasing breastfeeding opportunities. So there really needs to be, at least weekly drug screens done by mom to show that the THC is no longer a concern.
Yes, that's pretty standard in my courtroom, Ms. Thompson. There's no breastfeeding if there's THC or any other substances in the mother's body. So she wants to provide that, which is obviously a benefit to the child and for her and for the bond between the mother and the child. She'll have to maintain her sobriety. All right, that would be how I would be inclined to address that parenting time increase. Request for that would be asking for all the parties to come together to do that family team meeting with Ms. Conrad. I would endorse her concerns and safety planning around the THC usage, as well as anything else that may compromise the time between the mother and the child. Ms. Conrad or Ms. McVeigh, whoever can answer this, has there been trauma screens completed on the children? Are there trauma assessments pending or referrals for the children or the older child at least?
Yes, so there's a new system in place, and a Michigan's assessment was done by a specialist in regards to AL, especially because of her age, and a referral has been requested through our local CMH to have an assessment done to see if she could benefit from trauma services. So I will be starting that referral process.
All right, as a part of that, would they be able to consider the child and the parenting time and how that's affecting the child and whether or not an increase could be beneficial or detrimental?
We could request that for sure.
I think that
a weigh-in from them.
I would appreciate that.
Okay.
Okay, any other thoughts on parenting time or my directives to Ms. Conrad, frankly?
I don't have anything further, Your Honor. I believe in prior hearings, there were issues with who was conducting drug screening and how that was done. So I would just like a little bit of clarification on whether Ms. Conrad will be administering those or if there would be another way in order to have that facilitated.
Your Honor, if I can answer that, I know that since December, Ms. Hardy has been testing with her doctor weekly, like consistently since December.
Ms. Conrad, are you able to review those? Do you have concerns about that? What's your approach on that issue?
Yes, so there were 2 screens in December. They were not weekly. And then I did get a text from Ms. Hardy that she went this past week in January, but not weekly in January. So I have not gotten the results on 12/24 were negative for THC. So that was good to see. And then I have requested the results of the drug screen from this week and have not yet received them. We need to have weekly at a minimum to ensure that the THC levels are staying negative and not increasing for a while. We can monitor for a while and then we can reduce or get rid of, but this is new. This sobriety is very new.
Also, have you been able to talk with the doctor's office about their procedures and how they conduct those tests to ensure that there's no chance that we're getting false positives or that the levels are appropriate to make sure that there's no active usage or residual usage, all of those issues that come along with testing?
Right. I have not talked to the IHA professionals. I know CPS as part of their work with Ms. Hardy had arranged for those and had approved those as her screen of choice. And they are able to give pretty specific numbers because it was demonstrating a continual decrease in the amount in her system. So I have not had a specific conversation. I can if there are specific questions you would like me to ask, or we can require forensic fluid screens. That would be the other option because we're familiar with those.
Ms. Underwood.
Your Honor, as long as the ongoing worker is comfortable with the results from the doctor, I would defer to the court or to Ms. Conrad on whether requiring forensic fluids would be more appropriate in this case, but it sounds like Ms. Hardy would be willing to continue with weekly screens.
Very good. I think, well, I would leave it also to Ms. Conrad and Ms. McVeigh and Ms. Underwood to raise any concerns on those points and to also discuss that during the family team meeting after any time. Anything else?
I don't have anything.
Thank you.
Nothing further, thank you.
Okay, all right. Well, all prior orders will remain in full force and effect then, and we'll see you all in March, the end of March, for our final pretrial. I wish you the best of luck moving through all your discovery issues. And hopefully, if anything comes up between now and then, you know where to find me, whether it's by motion or even just asking for a settlement conference if any issues come up. If you're looking at retaining an expert, obviously, I would maybe anticipate a motion to have that person vetted for those purposes, or a stipulation if the rest of your co-counsel is satisfied with that person's requirements, but I don't want to have to deal with deciding whether or not a person is an expert on the day of trial.
Certainly, Your Honor.
So I appreciate you being cognizant of that issue.
This is in the matter of the Long children, file 24137.
All right, we are on record for the initial disposition, which has been docketed for today. We are on YouTube, so if you could avoid using the children's names directly, that would be good. We have the names of our participants, please.
Good morning, Judge Nicole Underwood, lawyer guardian ad litem for the minor children.
Good morning, Troy Tipton. Appearing on behalf of the Department of Health and Human Services, Your Honor, and I consent to Zoom. Thank you for allowing me to appear via Zoom today.
Sure.
I don't know if you're
Oh, good morning, Leslie Conrad, Fostering Solutions, Foster Care Supervisor.
Good morning, Your Honor. Brandy Thompson with and on behalf of Respondent Mother Robin Hardy, who is also present and seated to my right.
Robert Martin.
Catherine Dumont for father Tyler Long.
Tyler Long.
Okay, very good. All right, let's go to Ms. Underwood for her report.
Your Honor, I did provide a short report at the pretrial about a week ago. It will be the same as I have not seen the children within the last week. Would you still like me to reiterate that report?
Have you been able to review the court report? Has that contributed anything to your work in addition to your visit or not?
Your Honor, I was able to review the court report prior to visiting with the children last. Again, it was just over a week ago. So nothing has changed, or there's no updates I would have to provide at this time, but I'm happy to provide another report of the last time I did see the children.
Why don't you go ahead? I appreciate it.
Sure. I was, excuse me, able to briefly meet with both children. It was virtual, but they were with grandma, and the oldest child had gotten out of school that day, and she was excited and happy that she was able to get to meet with her cousins later on the day at a fun place in Ann Arbor. And so she was looking forward to that and talking to me about that. She seems to be doing well. I think that the therapy that she's been attending has been helpful for her, and just having somebody to talk to about all of the changes that are happening in her life. But overall, she was doing much better than the time that I had seen her before. I also got to see the younger child, the baby, and he was all smiles and happy. He was seemed very content. He looked healthy. He seems to be meeting all of his milestones and doing well from all of the reports I've seen from the medical reports lately. And both of the children's needs are being met in their current placement. And neither child is old enough to express any preference at this time. Thank you.
Yeah. All right, so I was just passed in a proposed case services plan, but it does not have signatures on it.
We do have a fully signed copy here. Okay, I can file across the hall when we're done, or can present to you now.
Well, we would need it for today's hearing, because if it is approved by all the parties, then it'll become part of our court order. So Deputy, if you can pass me that one, I'll just go on this one.
Okay, I was gonna trade that one back, but.
If you want it, you can have it.
Thank you.
So, Mr. Tipton, as you head into your questioning and witness presentation, I do want to review that I have the court report. I have a DHS 69. I have some information from back in October that appears to relate to Native American heritage search. I have some drug test results and some other exhibits, all just floating in the file. So if you could, as you navigate your presentation, let me know which ones, and all of us really, know which ones that you're asking to be part of the file versus just what was there in anticipation of trial.
Okay. Thank you. Can I call Ms. I'd like to call Ms. Conrad for some testimony.
Thank you, Ms. Conrad. Come on up to the witness stand.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Go ahead whenever you're ready.
Thank you. Ms. Conrad, you are the foster care specialist assigned to AL and RL's case.
I was assigned as a specialist as of December 13th, 2024, and then moved to a supervisor role in the case on March 24th of 2025.
Okay. And you prepared an initial case service plan for this case?
Yes, and the court report.
And the court report, and that's dated March 26th of 2025?
Correct.
Okay. And you also prepared a DHS 69. Is that for placement? I mean, I'm not sorry, not for placement, but for a foster care specialist change?
Correct.
Okay. And also, okay. Now, in regards to the case service plan for the parents, you had the opportunity to go over the case service plan for both parents?
Yes.
Okay. So in regards to Ms. Hardy, are you requiring her to participate in any type of parenting education classes?
Yes.
Okay. And is that the same for Mr. Long also?
Yes.
And is there a need for a psychological evaluation for either or both parents?
Yes.
Okay, for both parents?
Correct.
Okay. And you're requiring the parents to maintain suitable housing and legal source of income?
They are both required to maintain suitable housing. The income is not required for both parents if one income in the household is sufficient.
Okay, is the parent working at this time?
Yes, Mr. Long is working.
Okay. And is that's sufficient to provide for the household?
Correct.
Okay. Is there a need for individual therapy for the parents?
It is anticipated, yes. We are going to start with the psychological evaluations and then use those recommendations to guide the next steps for treatment for both parents.
And what type of parenting time? Well, let me strike that. So the parents are having parenting time that's supervised by the grandparents?
Primarily, yes.
Okay.
The maternal go ahead.
No. It's
maternal grandparents. I'm sorry, maternal grandparents supervise the bulk of the 4 times per week visitations. There are occasions where paternal grandfather, who's been approved by the agency, supervises some of the time, and then the agency supervises 2 hours a week.
And you're asking that continue?
Correct.
Okay. Are you asking for any discretion for unsupervised parenting time?
We would not be opposed to being granted discretion.
Okay.
To consider it in the future.
And how are the children doing in their placement?
The children are adjusting well. There is obviously there has been some emotional distress in AL, especially because she is older, in being separated from her family and not being able to reside in her home. But she's adjusting well as far as establishing a routine in her grandparents' home. She does well in school. Her teacher has very positive reports to provide. Both children have a predictable eating and sleeping pattern. The youngest child, the infant RL, is steadily gaining weight and meeting new developmental milestones as he should be.
Okay, great. And all right, thank you. I have nothing further. Thank you. Your Honor, at this time, I would ask the court to admit the initial, the case service plan, the court report, the DHS, the DHS 69. And that's all I have. Thank you.
All right, Mr. Tipton, do you have anything in your records about, and I just discovered that this has been happening relatively recently, but apparently we've had some, and I don't even think it was you, Ms. Conrad, I think it was probably from the department that was just filing things at the clerk's office, and the clerk's office was just receiving them, but I don't know if these were circulated to any of the attorneys or what was happening with it. But in this case specifically, there was apparently a Native American heritage search submitted, and the documentation that it was, that the 5598 inquiry was sent to the BIA, and that was submitted October 28th, 2024. And frankly, I have no idea why it's just now floating in my file for this morning, other than maybe these were just some things that had been consolidated. But do you have anything in your records about Native American heritage search, or whether or not that was completed?
I know that Ms. Trout had completed the Native American heritage search, and she had submitted those documents, and that was part of the initial filing for the in-home jurisdiction for this case back in October. And I'm not sure, and I apologize to the court, I'm not sure if I asked that those documents be admitted, because all the parties at that time, I believe with the exception of Ms. Thompson, had received those inquiries.
Your Honor, if I may, I believe the last time that we were here, it was indicated, I didn't receive the actual packet of the inquiries, but I believe one of the workers testified that it had been sent and had been received by I apologize, I'm not sure what tribe that received it, but I did get a copy of the card or the return card showing that had been received, but that they had not received any response yet from the tribe. And that was I believe that was last week when we were here.
Okay. Yeah, this is just weird. So the petition references that the 5598 was completed and mailed to the BIA, but that no responses have been received. So what I have from October has the green card that indicates that the BIA received it September 27th. I don't know that there's, Ms. Conrad, do you know if any other tribes were indicated for inquiry based on the BIA?
There were none, and there has been no formal response received. So we have the 5598 and we have the green card stating that the BIA received it.
Okay. Does anyone have an objection to me incorporating this as part of our file officially so that we have this Native American heritage search on the record?
No, Your Honor.
No objection.
No objection.
All right, so I'm going to receive that. That'll be our exhibit 3 for today. And then it looks like the rest of these were maybe just things that were prepared in anticipation of trial. I know we had the University of Michigan exhibit that was agreed to be admitted last time. But I also have some forensic fluids tests from November, as well as, yeah, I think just another copy of those. So should I just disregard those documents?
Yeah, I would have no objection if the court did that. I think that was a part of the initial case when the department filed for in-home jurisdiction. And I think the mom was voluntarily submitting drug screens to the department. But I would have no objection to the court discarding those. Yeah, we have a record of mom submitting clean drug screens for the foster care specialist.
All right, so your impression is that these were attachments to the original filing back in September?
Yes, Your Honor, I believe so because, yes. Because
Right,
initially, I'm sorry.
That's okay. I was just gonna tell you, the only attachment that I have to the original filing in September is 2 AOP certificates. And then the only attachment to the amended petition that was filed was that, and actually there's no, in December, there's no attachments to the petition itself, but there's a reference to a Native American heritage inquiry that should have been attached, but there was no attachment. So wherever the mix-up happened, I just think you should be aware of that, what's in the official legal file, in case you need to have a look at that to make sure it reflects accurately what it was supposed to and what was circulated, frankly.
Yes, well, I have no, I don't believe that the drug screen shouldn't have been filed with the court because there was an initial agreement in the initial petition that if mom submitted a certain number of drug screens, then we would withdraw our petition for the in-home jurisdiction. Then unfortunately, these new allegations arose, which sparked the amended petition. So I don't believe that those drug screens should have been filed at all. So I would ask the court to discard them.
All right, any objections?
No objection.
I'm in agreement, and I'm not sure specifically, I don't think I have those specific tests either, so.
Do you want them? You can have my copy.
I mean, I'll take them.
All right, Deputy.
Completeness of my file.
Sure. They reflect that they were received by the clerk of the court November 18th, but I'm disregarding them.
Okay, thank you.
There's 2 drug screens and then some Trinity Health records, so those are gone. All right. So I will receive then the court report, the DHS 69, and that Native American heritage search. Any questions for this witness, Ms. Dumont?
Ms. Conrad, you touched on the fact that you would like to have the discretion of supervised or unsupervised parenting time in the future?
I'm not requesting that, but I would not oppose it.
Okay, so how quickly do you think we could get to some unsupervised parenting time?
It's not something that the agency plans to do immediately. There are so many question marks about how the youngest child in this case was injured in the care of the parents. And so I believe some assessments need to take place and some information gathered by some service providers before we could consider that.
And is there anything specifically you want Mr. Long to work on, or other than getting the psychological evaluation done and continuing his employment?
Yep, the psychological evaluation would be our primary start, because that will give us recommendations to go from, and the agency will assist Mr. Long in making a referral for that and getting that moving. Yes.
Thank you.
And Ms. Conrad, with just a follow up on that, I think we can all agree that time is of an essence in this case due to the ages of the children, correct?
Correct.
And they've been out of the home for some time at this point, correct? When do you believe that you'll be making the referral for those psychologicals for mom and dad?
The paperwork will be completed next week, at the end of next week.
And will you be contacting the parents?
To specifically, I'm sorry, in what way?
When the referral is ready to go so that they know what they need to do?
Yes, we will provide the psychologist that DHHS contracts with the parents' contact information for scheduling purposes.
Okay.
Yes.
And with regard to the drug testing, Ms. Hardy, I believe we started official DHHS drug testing in January, is that correct?
End of December, beginning of January, yes.
Okay, and moving forward this year, has Ms. Hardy had any positive drug tests?
No.
Okay, and am I correct, and she has been testing once weekly?
Correct, approximately.
Okay, and is it your intent to reduce those, the amount of that drug testing at this time?
Yes.
Okay. And is that to 2 times a month then?
Correct. And then there will be a, you know, a monitoring of those results for a short period of time. And if they continue to remain negative, we'll go to once a month.
Okay. And Ms. Hardy has indicated that she actually is testing today, correct?
I heard that from you, yes.
Okay, all right. And so then this would be maybe week 1 and we would skip every other week.
Correct.
Moving forward.
Correct.
Okay. I just want to make sure everybody understands what we are doing moving over, so there's no miscommunication as far as that is concerned.
Correct.
I don't have any further questions for today.
Any questions, Ms. Underwood?
Good morning, Ms. Conrad.
Good morning.
Do you believe that the case service plan that has been signed by the parties in the department adequately addresses the needs for this family?
I do. It will be a document that changes as some major assessments are completed and we gain recommendations from specialists. Then those recommendations will be filtered into subsequent case service plans. But to start with, we do feel that this is adequate for this family.
And do you believe that the case services plan is in the best interest of the minor children?
Yes.
Thank you. I have no further questions.
All right, any redirect, Mr. Tipton?
No, Your Honor, thank you.
Okay, thank you for your testimony.
I apologize. Is it okay if I just ask one more question?
Yes, go ahead.
And it just slipped my mind. Ms. Conrad, you and I have had a discussion regarding Ms. Hardy's, the concern over Ms. Hardy's maybe level of reading comprehension.
Correct.
And we've discussed that in the context of this psychological that's going to be coming, correct?
Correct.
And it's your intent to notify the psychologist or whoever is going to be administering psychological that Ms. Hardy may need some extra time, may need some accommodations, so that she's able to complete that test appropriately, correct?
Correct.
All right, I just want to make sure that everybody knew that that was going to be taken care of. Thank you.
All right,
May
Mr.
I?
Monk.
I'm sorry.
Go
I have
ahead.
a quick question for the court, if I may.
I'll try.
One of the components of the case service plan is that the parents cooperate with a comprehensive trauma assessment for AL, who is 6 years old and potentially has witnessed trauma in her history. We would need that assessment court ordered at this time to be paid for by DHHS. If you could incorporate that into our court order today, that would be helpful to the case.
Any objections?
No objection.
Very well, I'll be happy to do that.
Thank you.
All right, any other witnesses today, Mr. Tipton?
No, Your Honor, thank you.
Okay, Ms. Dumont?
No, Your Honor.
Ms. Thompson? No. Ms. Underwood?
No, Your Honor, thank you.
Well, comments in closing?
Your Honor, I thank you. I ask the court to adopt the recommendation. Ms. Conrad, I believe that those recommendations are reasonable, with the addition of the parents cooperating with AL having a trauma-based assessment. As far as the parenting time, we would ask the court to maintain the status quo. It doesn't appear from Ms. Conrad's testimony that they're ready for unsupervised parenting time. I guess, the court could still leave it to the discretion of the department. But the recommendations as outlined, I'm sorry, I'm getting over. The recommendations as outlined, Your Honor, we ask the court to adopt and we believe they're reasonable. And we ask the court to find that the department has made reasonable efforts to preserve and reunify the family. And the permanency goal remains reunification. Thank you.
Thank you. Any comments, Ms. Dumont?
Your Honor, we would also ask the court to adopt the case service plan. Mr. Long is currently employed. He's already taken some parenting classes as well, so he's well on his way to completing it. And he'll comply with what's required of him to get his children back as quickly as possible. And we have no objection to the goal of reunification.
Thank you, Your Honor. Ms. Hardy has also completed some parenting classes, trying to get a head start on this case service plan. As it was indicated, she's been taking weekly drug screens, all of which have been negative. Is from the entire 2025. Parenting time is going well. They intend to, or she intends to comply with the case service plan. So I am fine with the court adopting that. I would ask that the court modify the current court order to allow DHH the discretion to move forward to unsupervised visits. As the case worker indicated, we have some pretty big evaluations coming up, and they may be making some recommendations. But I think it would be disingenuous to assume that those would all be negative recommendations. They may be very positive. And as she indicated, Aaliyah is struggling with, being away from mom and dad. So I think that discretion would be appropriate if those recommendations from the trauma assessment provider or the psychologist recommend moving to some type of unsupervised or increased visitation.
Yeah, Ms. Underwood?
Your Honor, I would also request the court to adopt the initial case services plan. I do believe that it is in the best interest of the children and addresses the barriers for reunification and the reason why we are before the court today. I believe that it will be in the best interest of the children, and I am not opposed to an order that would give the department discretion to increase or modify parenting time pending results from service providers and other reports that are forthcoming. Thank you.
All right, well, the court finds all interested parties are given notice for purposes of today's initial disposition. The case services plan does appear to accurately reflect the services necessary for these two parents to overcome the barriers for purposes of reunification with the children in this case. I will order the trauma assessment as well as parenting assessments, and the order will reflect that the parenting time is supervised, but that it may be modified to follow the recommendations made by any trauma assessment and or parenting time assessment as those come through. I would just ask our new caseworker to make sure that that's noted in the court report. If that is received and parenting time is modified, we're going to need to know that that's happening. I'm interested in seeing the psychological evaluation and those trauma assessments. And if there's any question whatsoever about whether or not it's a good idea to move forward with those recommendations, I would encourage you to reach out to Ms. Underwood to get her concurrence on that before moving forward, and even consider submitting a stipulated order noting that. And I just do that understanding that that there were some serious issues noted in the petition in this case. And I appreciate that the parents are willing to undertake some parenting education around these things, and look forward to ensuring that both children are safe in the future and able to stay with parents that are also safe and healthy. But I can, in good faith, just say, go ahead and do it, understanding that there is some significant risk associated with allowing unsupervised parenting time that could include not just neglect, but also potentially physical abuse. So I'll look for the department to be very vigilant on that point. And again, feel free to move into contacting the attorneys as well as Ms. Underwood on an FDM. In fact, I think I just talked myself into that on the record. Before you expand to unsupervised parenting time, get those recommendations and conduct an FDM, inviting all of the attorneys, including the guardian ad litem, to be part of that before you move on it. So that's what's going to go in the order, which will keep everybody in the loop. And I trust our attorneys and our guardian ad litem to make the right decisions on those points. And that will also allow the department to have open lines of communication with the attorneys during the process to ensure against any vitriol that decision may have otherwise engendered without those perspectives. All right, the children are placed with a relative. That is the safest and least restrictive under the circumstances, as the parents begin assessments and services to overcome the barriers preventing a return at this point. I'm glad again to see that they've already started some of those services, and I look forward to, again, those assessments and developments. And in the meantime, between now and our next report period, they will remain with those relatives. And I look forward to the reports. Our guardian ad litem and our case workers are all in compliance with their obligations. Thank you also to our litigators and the parents and all of the family and support systems that are in place for both the parents and the children at this time for this case. I'd like to offer to you, and Ms. Thompson, I know is coming in from out of town, and so is Mr. Tipton. I have the afternoon of June 30th at 2:30 or the afternoon of July 1st, which is Monday or a Tuesday. On Tuesday, I have 1:30 or 2:30. But if Monday works better, it's a 2:30 spot. Sorry here. That's quite all right. June 30th at 2:30 or July 1st at 1:30 or 2:30.
I think I'm available July 1st at either time, Your Honor. On June 30th, I have a matter at 2:30.
June or July 1st is fine.
1:30 or 2:30, any preferences?
Makes no difference to me.
All right, let's go for 1:30 on Tuesday, July 1st for our first review of the progress that the parents are making. And I will adopt the case services plan that will become part of today's court order. It will be attached to the order in addition to the advice of rights. So that's all for today. Best of luck to you moving forward. I'll have the order ready, but it won't be probably for another 10 or 15 minutes. So it's up to you if you want to wait for it. Unless there's any questions, that's all for today.
Thank you, Your Honor.